Welcome to today's deep dive. We are so glad you were here with us.
Really glad to be here.
Today, you are exploring the rigid, well, really mechanical rules that appellate courts use when they think a jury got a damage award completely wrong.
Yeah, specifically, we are focusing on general damages and that often misunderstood claim of loss of consortium.
Exactly. But before we get into the heavy legal mechanics, I want you to just think about how we usually view the justice system. We tend to think of judges as these, all-powerful figures who can just step in and fix anything that feels unfair, right?
Right, like they have a magic wand.
Yeah. Like, have you ever watched a massive lawsuit unfold on the news, seen a jury come back with a number that makes absolutely no sense, and thought, well, the judge will just fix that?
People assume that all the time.
They do. But here is the core legal problem you need to understand today. When a jury gives a plaintiff too little money, an appellate court cannot just step in and give the plaintiff whatever they want. They are not allowed to just pick a number that feels fair to them.
No, they absolutely are not.
Instead, they are bound by highly strict formulas and mathematical floors. It is almost a polite fiction, right? The justice system using mathematical formulas to pretend is being entirely objective about human suffering. So how do these courts actually fix a broken jury verdict without breaking the rules themselves?
That is exactly what we are going to dissect today. For you listening, here is our analytical path. Today's deep dive will systematically dissect the standard of appellate review for damage awards and the distinct elements required to prove a loss of consortium claim.
It's like a solid roadmap.
It is. We are going to do this using a step-by-step Socratic breakdown of a very specific and frankly harrowing case from our sources, which is Spangler v. Walmart. By the end of this, you will see exactly how constrained appellate judges really are when reviewing jury verdicts.
And you'll have a mental model for understanding exactly what is happening the next time you see a judge alter a multi-million-dollar verdict on the news. I am genuinely ready for this because the idea that a judge is handcuffed by a jury's bad math is just fascinating to me. So, to start us off and set the foundation for the listener, how does an appellate court actually go about changing a jury's financial award? And while we are at it, what does loss of consortium really mean in the eyes of the law?
Let's lay out the general rules before we get to this specific case. What's fascinating here is how incredibly mechanical this process is. So, Rule 1 is the appellate review of damages.
Okay.
This rule has two distinct elements. First, the appellate court must find a clear abuse of discretion by the jury based on the particular facts of the plaintiff's injuries.
Meaning they can't just disagree with the number.
Exactly. It is crucial to understand that they cannot just disagree with the jury. It is not enough for an appellate judge to say, I would have given this person more money. They have to find that the jury's number was so completely unreasonable that it defies basic logic.
That makes sense.
Then second, if and only if that abuse of discretion is found, the court can only raise the award to the lowest amount reasonably within a fact finder's discretion. Conversely, if the jury gave way too much money, they can only lower it to the highest reasonable amount.
Wait, really?
Yes. They are legally barred from picking an ideal, fair, or median number in the middle.
Wow. So they are essentially forced to ask, what is the absolute most stingy number a reasonable group of people could possibly come up with, and then they have to award exactly that?
Precisely. They are legally handcuffed to the floor or the ceiling of reasonableness.
That is intense. And the second rule?
Rule 2 is loss of consortium. Now, this claim does not belong to the person who actually slipped and fell or got into the car crash.
Oh.
This claim belongs to the spouse or family member of the injured party.
The person standing beside them, essentially.
Right. And it is divided into two element categories. First, you have the pecuniary components. Pecuniary is just a legal term for direct, quantifiable financial impacts like the loss of services or financial support.
So, like, did the family have to hire a full-time nurse or a housekeeper because the spouse can no longer do those things?
Exactly. And second, you have the non-pecuniary components. This is the emotional and relational side, which includes the loss of love, companionship, affection, society, sexual relations, comfort, and solace.
Okay, those are the rules. To truly understand how this works in practice and to see just how visceral these cases can get, we need to look at a real-world scenario. To test these rules, we are going to use the case of Spangler v. Walmart, decided by the Louisiana First Circuit Court of Appeal in 1996. Let's analyze Spangler v. Walmart. First, what are the legally dispositive facts?
The essential facts, the actual events that legally matter for the judge's decision, are as follows. On June 14, 1991, Kathleen Spangler went to a Walmart in Zachary, Louisiana. She slipped and fell hard in the women's restroom.
Just a terrible
It
situation.
really was. Her husband, John Spangler, had been waiting out in the hall. When he heard her call out in distress, he opened the door and found his wife on the floor near a red substance and a crushed cup.
And we know how it got there, right?
Yes. To establish fault, we also have testimony from a store stock clerk, Harry Scott Jr., who confirmed that the assistant manager had explicitly told him to clean up a liquid spill in that very restroom earlier on the day of the accident.
And Kathleen's injuries were not just a bump and a bruise. They were incredibly severe, correct?
Yes, horrifically severe. Her medical journey is the most crucial fact here when we talk about evaluating damages. She was initially diagnosed with a fractured tailbone, but her extreme pain persisted long after it should have healed. She went through an MRI, a CT scan, and a litany of conservative treatments. Ultimately, Kathleen endured 5 separate spinal surgeries.
5.
4 major spinal fusions were performed by one orthopedist, Dr. Watermeyer. But even after 4 fusions, she was still suffering from debilitating, severe pain.
That is just agonizing to even think about.
It truly is. So she sought out a second surgeon, Dr. Nicholson. He had to perform a 5th surgery, entirely revising the lumbar fusion in her lower back. And during that 5th surgery, Dr. Nicholson actually had to insert a battery-operated internal bone stimulator deep into her back just to aid the bone healing process.
Yeah, so she has a battery-operated mechanical device permanently implanted in her spine after 5 separate surgeries because she slipped on a spilled drink at Walmart.
Exactly. And despite this agonizing, life-altering ordeal, the trial outcome was genuinely shocking. The jury awarded Kathleen only $64,000 for her physical pain and suffering. Furthermore, they awarded exactly $0 to her husband John for his loss of consortium.
It's $64,000 for 5 back surgeries and an implanted battery that barely covers the hospital parking, let alone years of agony. And nothing for the husband who had to watch all of this happen. That is staggering. And what was the core legal issue?
The precise legal question before the appellate court was this: did the jury abuse its discretion by awarding an insufficient amount for Kathleen's pain and suffering, and by failing to award any damages to John for loss of consortium?
Okay, so the appellate judges see this horribly injured woman getting pennies, and they have to figure out how to fix it without overstepping their bounds. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied 2 black-letter rules, meaning the strict, established, unyielding legal principles. The first rule is the appellate damage modification rule, which contains 2 testable elements.
Go ahead.
Element 1. The court must find a clear abuse of discretion by the jury based on the facts and circumstances peculiar to the plaintiff's case. Element 2. If an abuse of discretion is found, the court may only raise the award to the lowest amount reasonably within the trier of fact's discretion.
Right, the floor we talked about.
Exactly. Then the second rule is the loss of consortium rule, which requires the evaluation of 2 testable categories of elements. Element 3. Pecuniary components, such as loss of household services and financial support. Element 4. Non-pecuniary components, including love, companionship, affection, society, sexual relations, comfort, and solace.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the clear abuse of discretion regarding the general damages?
Let's look at the sub-issue for this first element. Was the jury's award of $64,000 for pain and suffering a clear abuse of discretion?
Which seems obvious to us, but they have to prove it.
Right. To apply the facts to this rule, the appellate court didn't just look at their own feelings. They looked closely and objectively at the sheer, undeniable severity of Kathleen's medical ordeal. They highlighted the number and nature of the procedure specifically, 4 different spinal fusions performed by Dr. Watermeyer, followed by that massive 5th revision surgery by Dr. Nicholson that required the implantation of the battery-operated internal bone stimulator.
You can't argue with the battery in the spine.
You really can't. So the court's conclusion on this element was an emphatic yes, awarding only $64,000 in general damages for a woman who endured 5 spinal surgeries and had a mechanical device implanted in her back was firmly below what any reasonable trier of fact, any reasonable jury could assess. The first element was met. The jury clearly abused its discretion.
Wow. Okay, so the jury's number was clearly absurd. Understood. Now what about the second element, modifying the award to the lowest reasonable amount?
The sub-issue here is, how much can the appellate court increase the award to correct this abuse? Applying the facts to this strict rule, the appellate court acknowledged their handcuffs. They noted that they cannot just give Kathleen her ideal number, nor can they give her what they personally, as human beings, think is the most fair or just compensation for 5 back surgeries.
They can't just fix it.
No, they are legally bound to that floor of reasonableness we discussed. They must determine the absolute minimum amount that a hypothetical reasonable jury could have awarded without it being considered an abuse of discretion.
So what was the number?
The court's conclusion on this element was to raise the award for physical pain and suffering to $250,000. They expressly declared that $250,000 is the lowest general damage award reasonably within a jury's discretion for the specific extensive injuries sustained by Mrs. Spangler.
That is wild to think about. They probably thought she deserved far more than $250 grand, but they were forced to pinpoint the lowest possible number that wouldn't be considered legally insane. So the court fixes the wife's damages. But we still have the husband, John, sitting there with $0. We need to look at his claim. Understood. Now let's look at the consortium claim. What about the third element, the pecuniary components of loss of consortium?
The sub-issue here is, did John Spangler suffer a pecuniary or quantifiable financial loss of services or support because of his wife's injuries? In applying the facts, the court looked at the financial realities of the Spangler household. John claimed a rate of financial support, but the evidence showed that Kathleen's income prior to the accident was sporadic and minimal.
So it wasn't a massive financial shock in terms of wages.
Correct. She was not the primary breadwinner in a way that financially devastated him when she couldn't work. Furthermore, regarding the loss of household services, the court noted that the Spanglers did not incur any actual expenses to hire outside help. They didn't hire a maid or a nurse or a cook to perform the household services that Kathleen previously managed.
Okay, so because no money went out the door, the court viewed it differently.
Yes. Therefore, the court's conclusion on this element was that it was not met. John had no valid claim for the pecuniary components of loss of consortium.
Okay, so they didn't have to hire a nurse, meaning no direct financial hit. That makes sense, even if it feels a little harsh. But what about the emotional side of the marriage? Losing the person you love to constant, agonizing pain has to count for something. Understood. Now, what about the fourth element, the non-pecuniary components?
The sub-issue is, did John lose the non-pecuniary benefits of marriage, such as love, affection, society, comfort, or sexual relations due to the Walmart fall? Applying the facts, the court looked deeply at John's testimony about his life behind closed doors. He testified that he absolutely still loves his wife, but since the accident, their social life had changed drastically.
Yeah, you can't really go out and live a normal life with that kind of injury.
Exactly. They couldn't do the things they used to do. Their sexual relationship had suffered immensely. Additionally, he and his stepson, Toby, now had to undertake almost all of the household chores themselves because Kathleen physically couldn't. Now, the court was careful to note a crucial, very real mitigating fact. That Kathleen had suffered numerous medical problems and surgeries in the 4 years prior to the Walmart accident. She was not in perfect health before she slipped. Those pre-existing issues clearly had already affected the marriage to some degree. However, the court found that the severe exacerbation caused by the slip and fall of the 5 new surgeries, the implanted battery, was undeniable.
It made a tough situation much, much worse.
Definitely. The court's conclusion was that this element was met. Even factoring in the prior medical history, the total failure of the jury to award any damages for this loss of companionship in society was an abuse of discretion.
It is so fascinating and honestly a little uncomfortable to hear a court analytically weigh the value of a marriage and assign a dollar value to intimacy and companionship. So we have all our pieces on the board. And after analyzing all the elements, what was the court's final conclusion?
Synthesizing all of this, the appellate court's ultimate holding was to formally amend the trial court's judgment. Kathleen's general damages for physical pain and suffering were forcibly raised from the absurd $64,000 to the lowest reasonable floor of $250,000. And John Spangler, who initially received $0 from the jury, was awarded $20,000 for his loss of consortium and society. In all other aspects, the trial court's judgment was affirmed.
Okay, to ensure you, the listener, never forget this lowest reasonable amount rule, I want to introduce a highly visceral, completely unforgettable hypothetical. I really want to drive home how strict these appellate handcuffs actually are, even when the facts are downright disgusting.
I'm bracing myself.
Imagine a plaintiff is walking through a grocery store, and they slip on a massive puddle of liquefied fermented mayonnaise that has been rotting in the aisle for days. It is vile. The fall is catastrophic. They shatter their tailbone so thoroughly that human doctors cannot fix it. They actually have to perform a full cybernetic spine replacement.
Oh, wow. A cybernetic spine.
Yes. The pain is unimaginable. They will never walk the same way again, and they beep when they go through metal detectors.
No.
They take the grocery store to court, and the jury finds the store completely liable. But then, inexplicably, the jury awards the plaintiff exactly $1 for pain and suffering.
Yeah.
One single dollar.
That is an absolutely horrifying, disgusting scenario, but honestly, it is the perfect way to test the rigid mechanics of this doctrine. Let's analyze that hypo. If this fermented mayonnaise catastrophe comes before the appellate judges, they are going to look at that $1 award and immediately find a clear abuse of discretion under Element 1. $1 for a cybernetic spine replacement caused by rotting condiments is obviously absurd. No rational human being could arrive at that number.
Right. It's just offensive.
But here is where the rule bites under Element 2. Those appellate judges might be absolutely horrified. They might look at the plaintiff's agony and personally believe that the plaintiff deserves $10 million in general damages to make them whole. But they are legally handcuffed. They cannot substitute their own ideal number.
So they can't just say, let's give them the $10 million.
No. They must ask themselves, what is the absolute minimum amount a reasonable jury could award for a cybernetic spine replacement without it being an abuse of discretion? If they determine that the floor of reasonableness, the lowest possible number a stingy but rational jury would give is $2 million, then the appellate court must award exactly $2 million. They cannot give the $10 million they think is right. They are bound to the floor.
It is such a strange restriction on judicial power. You really see how the system twists itself into knots to try to preserve the role of the jury, even when the jury makes a massive, insulting mistake. So as we wrap up this deep dive, we want to make sure you can apply this knowledge practically. Could you synthesize everything we've discussed today into a diagnostic checklist? How can the listener practically apply this framework as a mental model the next time they see a crazy legal headline on the news?
Absolutely. If we connect this to the bigger picture, you need a reliable method to parse through these types of legal outcomes in the real world. Here is your actionable, step-by-step diagnostic checklist to figure out what appellate judges are doing behind the scenes. Step 1. Identify the standard. First, ask yourself, is the jury award an abuse of discretion?
And we look at the facts for that.
Yes. To answer this, do not look at your own feelings. Look closely at the objective medical facts. How many surgeries were there? Were there permanent devices implanted, like a bone stimulator or our hypothetical cybernetic spine? The more severe and quantifiable the medical intervention, the easier it is to prove the jury's number was an abuse of discretion.
Makes perfect sense.
What's next? Step 2, apply the modification floor or ceiling. If you find that an abuse of discretion exists, remember the constraints. The judges cannot pick a fair number. If the jury's award was too low, find the lowest possible reasonable amount and raise it only to that floor. If the jury's award was astronomically high, you must find the highest possible reasonable amount and lower it only to that ceiling.
Finding the limits, basically.
Exactly. And finally, step 3, bifurcate consortium. Always split a loss of consortium claim into 2 distinct buckets. First, the pecuniary bucket. Did the spouse have to hire a maid? Did they lose actual financial support or wages? Second, the non-pecuniary bucket. Who does the chores now? Did the social and sexual relationship suffer? Did they lose comfort in society? You must analyze both of these buckets independently to determine if the claim holds up.
That checklist is incredibly helpful.
Right.
It is like having X-ray vision for the legal system. So what does this all mean for you, the listener? Why should you care about the exact mechanics of how appellate courts adjust damages? It matters because it shatters a very common misconception. It shows that appellate courts aren't just do-overs for a trial. You don't just go to an appellate judge and say, the jury was mean to me, please give me what I asked for.
You really don't.
These courts are highly constrained mechanisms of legal math. They are bound by rules that force them to respect the jury system, even while they're actively fixing a jury's mistake. But I want to leave you with that final provocative thought we teased at the beginning to mull over on your own. The entire justification for this lowest reasonable amount rule is that it is meant to respect the jury's original power as the finder of fact. We force appellate judges to act with restraint. But think about what we are actually asking them to do. If an appellate judge is forced to guess the absolute minimum number a hypothetical reasonable jury would award, isn't that just a polite fiction? Isn't it just a complex legal theater for the judge picking a number they intuitively feel is right anyway?
It's a great question to ponder.
Where exactly is the objective line between a jury's discretion and a judge's imagination. As you digest the Spangler case and the mechanics of appellate review, I encourage you to consider whether true objectivity is even possible when we are trying to put a strict mathematical price tag on human suffering. Thank you for joining us on this deep dive. Keep questioning the rules, and we will see you next time.